So apparently, according to judges in Connecticut, your AR-15 might not actually be legal for self-defense. Yeah, let that sink in. The most popular rifle in America, owned by millions, used by civilians, law enforcement, and now is being questioned as if it's some exotic weapon nobody should have their hands on. And the reason? Because a bunch of black robe politicians masquerading as judges think they know better than you about how you are allowed to defend yourself. You see, a federal appeals panel just upheld Connecticut's so-called assault weapons ban. This all goes back to the laws they passed after the Sandy Hook tragedy. Gun rights groups challenged it, arguing that banning AR-15s violates the Second Amendment. But the Second Circuit Court of Appeals came back with a ruling so twisted, so creatively anti-Second Amendment that it basically rewrote what the Constitution says on the fly. The Second U.S. Circuit Court of Appeals said groups challenging a 2013 law banning assault weapons and a second gun control law enacted a decade later could not show that the guns they are still able to possess, including several semi-automatic handguns, are not sufficient for self-defense purposes. So let me get this straight. The government gets to decide what's sufficient for me to defend my life. That's like telling someone, hey, you don't need a modern car. You can still get around just fine on a bicycle. No, self-defense isn't about scraping by with sufficient. It's about having the best possible tool to protect yourself and your family when seconds matter. The arrogance here is insane. They're not protecting you, they're limiting you. The appeals court said the Second Amendment lets legislators implement targeted regulations designed to protect residents and their children from experiencing tragedies like the December 14, 2012 shooting at Sandy Hook Elementary School. Translation, we can ignore your rights if we think it makes us feel safe. That's not how rights work. Rights don't exist only when they're convenient. The entire point of the Bill of Rights is that it sets limits on government power, especially when emotions run high. Using a tragedy as an excuse to gut fundamental rights is emotional blackmail dressed up as law. And then there's this gem from the judges. The proliferation of unusually dangerous weapons has led to a frequent, growing, and extremely lethal threat to public safety, actual and widely perceived, that the authors of the Constitution could not have imagined. First of all, unusually dangerous? Every weapon is dangerous. That's the point. A baseball bat, a kitchen knife, a car, they're all dangerous in the wrong hands. Second, the founders absolutely did imagine this in terms of our capabilities with the guns we have. They had just fought a revolution against the most powerful military in the world using cutting-edge firearms of their day. They didn't write the Second Amendment for hunting. They wrote it so the people could stand on equal footing against tyranny, foreign or domestic. If they could imagine muskets in 1776, they sure as hell could imagine advancements in firearms technology. They weren't idiots. They wrote a principle, not a product manual. The judges even compared the AR-15 to the Thompson submachine gun and said historical legislators regulated these unusually dangerous arms like here after observing the regulated weapon's unprecedented lethality. Nice try, but the Thompson was a fully automatic machine gun, and AR-15 is not. You don't get to lump them together because they look scary to you. That's like saying a Dodge Charger is the same thing as a Formula One car because they both go fast. The comparison is dishonest, but the dishonesty is the only way they can try to justify their position. And here's where it gets even more ridiculous. For years, the standard has been simple. If a firearm is in common use, it's protected. The AR-15 is the most commonly owned rifle in America, period. But now these judges are trying to twist that into saying it doesn't count unless it's commonly used specifically in self-defense shootings. Think about how insane that is. By that logic, your First Amendment rights wouldn't apply unless you were constantly giving political speeches. It's like saying you only really have free speech if you use it in one narrow, pre-approved way. That's not how rights work. And then they talk about the stupid category called unusually dangerous. As if weapons isn't supposed to be dangerous when used for its intended purpose. It's dangerous towards the criminal trying to kill me. That's the point. That's literally the point. A gun is designed to stop a threat. If it wasn't dangerous, it would be useless. And yet somehow the court thinks that labeling something as too dangerous magically overrides the Second Amendment. But the worst part, they quietly drag back something the US Supreme Court already told them they can't do. A balancing test. In Bruen, the court said flat out that judges can't weigh your rights against some vague idea of public safety, because if they can do that, guess what? They'll always say public safety outweighs your rights. And that's exactly what just happened here. The judges basically said, we'll decide what's appropriate for you to own. That's not law, that's a dictatorship of feelings. This ruling isn't just about Connecticut, it's about the precedent it sets for the entire country. If courts can redefine common use, invent fake categories like unusually dangerous, and sneak back balancing tests that the Supreme Court already threw out, then no firearm is safe from being banned. And at the end of the day, here's the truth. These judges can sit in their chambers and come up with whatever loopy ass idea they want about what's acceptable for you to defend yourself with. But none of them are gonna be there if someone kicks in your door at 2 a.m. None of them are going to shield your kids when evil shows up at your front door. When that moment comes, it's just you and your gun. Which is why, as far as I'm concerned, their opinions mean nothing to me. Because at the end of the day, I am the militia. The very militia the founding fathers were talking about in the Second Amendment. They weren't talking about the government, the reserves, or the Coast Guard. They were talking about the people, ordinary citizens with their guns, ready to stand up to tyranny, foreign or domestic. That's what they meant. That's who we are. That's why I came up with the I'm the militia design, because people need that reminder. You are the militia. I am the militia. We are the militia. That's what the Second Amendment is about. So if you want to wear that reminder on your chest, check out the I Am the Militia collection at shop.masquerading.com. I'll put a link in the description section of this video. We got hats, hoodies, shirts, drinkware, you name it. We've got it all. Links in the description section. Because the truth is, no matter what these judges say, you and I both know we are the militia. One thing's for certain and two things are for sure. Politicians and tech giants don't want gun content to be recommended to you. And we're all fighting this culture war together. Now, you can help do your part by liking, commenting, subscribing to the channel, but most importantly, sharing this video with at least one person. Together, we can stop the suppression of our 2A rights. And don't forget to click the link in the description section of this video for the products that I mentioned in this video.